Good evening, everyone. Welcome to our program for this evening. It is titled Know Your Rights, Religious Freedom in the Public Schools. My name is Luke Anderson. I'm a Constitutional Litigation Fellow at Americans United. Before we get started for this evening, I'm just going to go over a few points of housekeeping. First, ASL interpretation is available. Our interpreter is Angela Reel. And in your meeting controls toolbar, you can click the interpretation icon, which is a globe, to enable this feature. If you don't see it, you may need to update your Zoom client, your app, and you do have to be on the app. This feature is not available via web browser. Next, closed captioning is available, so you can turn it on by clicking the CC button in your meeting controls. Please post your questions in the Q&A box or the chat. We'll do our best to get to as many as we can later in the program. This webinar is being recorded, and all registrants will receive an email tomorrow with a link to this recording, as well as links to the resources discussed tonight. So this program is presented by Americans United for Separation of Church and State. AU, Americans United, is the only organization dedicated solely to defending the separation of church and state. We are the shield protecting the foundational American principle of freedom of religion, including the right to believe or not believe for all. Our co-sponsors for this evening are the ACLU of Oklahoma and Secular Student Alliance. Please be sure to visit their websites. You can find links to those websites in the chat. Our panelists for this program are Ian Smith, who is a staff attorney here at Americans United, and Rebecca Markert, VP and Legal Director at Americans United. And I'll pass it off to our two panelists.
Hello, everybody. As Luke said, I'm Ian Smith. I'm a staff attorney here at Americans United. I do our non-litigation advocacy and our legal intake. So when people have questions about possible violations of separation of church and state, those come to me and I review them, and sometimes do non-litigation advocacy like letters to try and resolve them. So we're doing this webinar because it's back to school time, as I'm sure you're all aware, and you know, I've been at AU and doing this work for 16 years now, and every single year I have done this, complaints about religion in the public schools are the #1 thing that I deal with. And that is despite the fact that this has been, like, religion in the public schools questions have largely been considered settled in the law, like something that is very straightforward and easy to understand, but it's always a problem, and it's always something that we have to deal with. So in this talk, I'm gonna give a brief overview of what the legal landscape looks like for some of the terms mean whenever we're talking, us lawyers are talking about separation of church and state. And then I'm going to talk about I'm going to give a little bit of an overview of some of the most common things that we see in the public schools. If you want more information about public law, the law surrounding separation of church and state in the public schools, AU has created a series of Know Your Rights guides, which go into a lot more detail. You should see a link to that in the chat. I'm not going to go over that in extensive detail. You can look at those if you want to, and the Q&A portion of the session will offer plenty of opportunity if you want more information about a specific topic. So, okay. And also, the presenters here are lawyers. We have a tendency to talk in jargon, and if we say anything that is incomprehensible for whatever reason, because it's way too technical, be sure and let us know, and we'll try and go back and put it into simpler terms. So, what do we mean when we say the separation of church and state? Well, the First Amendment, it's located in the First Amendment, and the First Amendment says, Congress shall make no law respecting an establishment of religion or restricting the free exercise thereof. That's it. Then that first bit about respecting an establishment of religion, that's it. That's all you get, right? And conservative pundits love to say that separation of church and state isn't in the Constitution. The words aren't there, but the principle is embodied in that sentence from the First Amendment. And it does say Congress shall make no law. So originally, it was supposed to apply only to the federal government, right? The Bill of Rights only applied to the federal government. But after the Civil War, we have the 14th Amendment. And the 14th Amendment has two provisions in it that are critically important here. It says, no state shall deprive any person of life, liberty, or property without due process of law, and nor deny to any person within its jurisdiction the equal protection of the laws. And the Supreme Court has, over the years, used those two clauses, which are respectively called the due process and equal protection amendment clauses of the 14th Amendment, to apply many of the provisions of the Bill of Rights, although not all, to the states as well as the federal government. And so that the first portion of the First Amendment, which is to say what we lawyers call the Establishment Clause, Congress shall make no law respecting an establishment of religion, has been applied to state and local governments via the 14th Amendment's due process and equal protection clauses. So it does apply to all levels of government, not just the federal government. And it has been that way for most of the 20th century and the 21st century. So I want to talk a little bit about the legal tests that we use to determine whether something is a violation of the Establishment Clause or the separation of church and state. So now there's a long history in the 20th century of separation of church and state cases, starting as early as the 1940s and going up through the end of the century, right? And there's a lot of robust law protecting especially public schools in those years. Starting in the early 1980s, the Supreme Court sort of collected all of that law into something it called the Lemon test in a case called Lemon v. Kurtzman. And Lemon essentially had three prongs. And if you violated any of the prongs, any of the individual tests, then you violated the Establishment Clause. So Lemon basically said that the government could not take an action that had the intent of supporting or endorsing religion. The action could not have the effect of supporting or endorsing religion. And government could not entangle itself with religion or religious organizations, right? Altogether, we call the Lemon test, it is also known as the endorsement test, because endorsement tended to be the word that got thrown around out there. I don't want to spend a whole lot of time on Lemon because Lemon doesn't exist anymore. A couple of years ago, in a case called Kennedy versus Bremerton School District, the Supreme Court threw out Lemon and said that it's no longer good law. And they replaced it with something that they call the history and tradition test, which sort of specifically relates to the historical intent of the founding fathers. It's been used in other contexts for separation of church and state, most commonly in situations of legislatures, whether that be state or local legislatures, opening their meetings with prayer. The court pointed to a historical tradition based in the earliest days of the United States Congress, where they opened with a prayer and they said, see, this is consonant with the history and tradition of our country, and therefore it's fine. And so they've tried to apply this, or they've said that we now apply this to all cases in which the Establishment Clause happens, or needs to be, when we need to figure out whether something is a violation of the Establishment Clause. The problem with that is that there is no similar history of public school activity as there was, going back to like the first Congress, right, that they used in other cases. Public schools didn't exist at the formation of the country, right? They're, historically speaking, a fairly recent development. So really and truthfully, nobody really knows exactly how to apply this nowadays. The important thing to realize is that Kennedy overruled Lemon in that it overruled Lemon's tests right? Those three prongs that I talked about earlier. But it did not overrule every case that ever depended on limit, because a lot of the principles that undergirded lemon, right? A lot of the ideas that the Supreme Court was collecting when it handed down lemon are still there, right? Those cases, from pre-1980 or 1982, whenever lemon was handed down, right? From before lemon, those are all still good law. The Supreme Court has not overruled them. They're still there. They're still on the books. You can still rely on them, right? So practically, what this means is that all of these principles that form our understanding of how religious rights work in the public schools still remain good law. And until the courts say otherwise, that practically means that not a lot has changed. That may be different coming up in the near future when the court takes on more cases and gives us more guidance on exactly what Kennedy is supposed to mean. But right now, we're still largely operating under the same legal framework that we were operating in for most of the 20th century and all of the 21st century up to Kennedy. So let me talk. That's the very basic framework for all the stuff you're going to hear Rebecca and I talk about today, right? That's sort of the stuff that we look at in very broad strokes. So let me talk now just a little bit, and then I'll turn it over to Rebecca about some of the biggest things with the public schools in terms of what we see about as violations and the kinds of things that are problems. So the big thing that we look for nowadays is coercion. Coercion, what means the government putting pressure on someone to engage in religious activity or to listen to religious messaging, stuff like that, right? Coercion was always often its own little world, its own sort of thing, right? Like even when something didn't meet the three lemon prongs back in the day, if you had government coercion, you still had a violation, right? And the Supreme Court has not touched coercion, so coercion is a big thing. We always look for coercion. But the thing about schools is that schools are inherently coercive environments. Students are required to be there by law, right? And parents that don't send their kids to public schools can be charged with crimes, under truancy laws and stuff like that. School officials are presented as authority figures who impart knowledge and correct modes of behavior, and they can influence students to follow particular religious examples. So because of that context, because public schools are coercive in that way, it is one of the core things about public schools, and one of the reasons that the courts are so protective of separation of church and state in the public schools is it is very easy, even unwittingly, for school officials to coerce students into engaging in religious activity or paying attention to religious messages. Another big rule is that schools are not allowed to sponsor, conduct, or promote prayer or other religious activities. That includes, it includes students, obviously, right? School officials imposing religious content on students at official activities and stuff like that. It also, however, includes administration imposing religious content on staff. Actually, one of the biggest content areas in recent years that I've been writing letters on is administration officials including religious content in staff only activities like in-service or professional development meetings, right? They'll invite pastors to pray, stuff like that. Can't do that. That's also coercion, right? In fact, I think you'll probably hear Rebecca talk a little bit about this in the state of Oklahoma with Ryan Walters, because he's doing a little bit of pressuring on himself of school officials in this way. Teachers, after Kennedy, teachers may engage in some kinds of religious activity as long as those activities are brief, private, and do not seek to involve students. We used to say that they had to do them completely out of sight of students, but Kennedy kind of made it to where that's not the case anymore. They can, the thing now is that it has to be something that's clearly private, right? And that they're not trying to get students involved with. you know, and that this can also include things like, wearing small like religious jewelry or other kinds of minor religious clothing, not like a t-shirt with like a huge religious message on it or something like that, but small personal effects, that kind of thing. It's a fine line, and we always have to look at context whenever we're looking at that sort of stuff. And then the last thing I wanted to touch on, because this comes up a lot, is that schools are allowed to teach factual information about religion, but they may not teach religious dogma as fact. So this is a so you often see like in like social studies classes, people get very upset when their kid might have to learn something about another culture's religious practices. Islam comes up a lot, right? People get very upset if they have to learn anything about Middle Eastern culture and Islam in particular. But as long as it's just factual information, that's okay, right? They can do that. But they can't have they can't teach you like that something that is based in religious belief is true, factually true. The example that I like to give the most about this is, so take um take the story of God parting the Red Sea for Moses and the Israelites, right? So if you had that story and you presented it in, say, an English class as a story, and you had it in the context of trying to teach students what, like the phrase parting the Red Sea is often used as like a metaphor, right? For someone coming in and smoothing the path, right? So if you taught it to students in that context, where you're trying to explain this, like this phrase in context in another work, yeah, you can do that. That's fine. But if you put that same story in a history class and you say, this is what happened, right? That's not fine, because it requires, for you to accept that to be something that is historically true, it requires faith, right? It requires a belief in God and a belief that God will come down and do miracles, and other things such as the existence of someone called Moses, right? Like a bunch of stuff like that. So it's all very context sensitive, but we see a lot of complaints along these lines. Once again, the Know Your Rights guides are a great place to go and find out more about a whole variety of different topics that touch on these kinds of things in the public schools. But right now, I don't want to go over them all because it would take the rest of the session. And right now, I want to turn it over to Rebecca to talk more about specific issues that we're seeing in the states. Go ahead. Well, I think you're still muted.
Always happens. Thank you very much, Ian. My name is Rebecca Markert, and I am the Vice President and Legal Director here at Americans United. I've only been with AU for about 4 months, but I've been working also in the church-state space for about 16 years, so just as long as Ian. So I think we both have a lot of good knowledge and stories about how these issues permeate in our public schools. As Ian mentioned, my job tonight is to cover the ways that church-state violations have manifested themselves in public schools in states around the country, and to give specific examples of what AU is doing to combat those violations, whether it be monitoring the situation, investigating, or litigating. Since Kennedy has been decided 2 years ago, we have seen a surge in church-state violations and potential violations in very specific areas that I'm going to cover tonight, in the area of chaplains in the public schools, postings of the 10 Commandments in public school classrooms, and different attempts to inject religion into public school curriculum. You're going to notice a trend in the states that I'm going to be covering. I'm going to be discussing things in Texas, Louisiana, Oklahoma, and Florida for the most part. But I want to be clear that it is not limited to the South or the Bible Belt. These violations can come up in any part of the country if there is a political will to do it. And as I talk through some of these bills, you'll understand that it isn't really just the Bible Belt where these things are happening. But we are going to be focusing on those states tonight. So the first issue that I'm going to talk about is chaplains in the public schools. This has been an issue that has really dominated the last 2 years. Before efforts in the state legislatures to get schools to employ chaplains more formally were introduced, we saw chaplains often in public schools, usually as part of a football program. For example, there would be a chaplain who would come in and pray with the team, or have them come to religious services and do team building efforts and things like that. But since Kennedy, there really has been an effort to make sure that chaplains are available, usually as school counselors, to public school students. And that's what we're talking about when I'm talking about the bills that have been introduced. The state of Texas was the first state to pass a bill like this about chaplains in schools in 2023. And that success in that state inspired copycat legislation around the country. In fact, this year alone, we saw 15 states introduce bills to have chaplains in our public schools. Those states are Alabama, Florida, Indiana, Iowa, Kansas, Louisiana, Maryland, Mississippi, Missouri, Nebraska, Ohio, Oklahoma, Pennsylvania, and Utah. The good news is that most of these state legislatures are now closed for the remainder of the year, and a lot of these bills did not pass. In fact, only 2 did, and I'm going to talk a little bit about those. The first state to pass a bill was Louisiana. In that state, the chaplain bill allows each city, parish, or other public school board to employ chaplains or accept them as volunteers. It does not explicitly require school boards to hold a hearing or a vote to implement a policy like that. So we haven't been monitoring it as much, but the law isn't good. In Louisiana, it gives blanket immunity to chaplains, which is a very big problem. A place where we are very active in this chaplains issue is in Florida. In Florida, they passed HB 931, which allows each school board to vote on a policy for chaplains. And as far as we know, no school districts in Florida have actually enacted a policy to employ chaplains in their schools, but there have been some developments. One in Miami-Dade County, the school board there directed the superintendent of that school district to study the issue and to present on it at a meeting in July, but actually that hasn't happened yet. Another area, Osceola County, is a more interesting area because that is where Governor DeSantis actually signed the bill, HB 931, into law. So there is a school board member in that county who's very vocal and very persistent on trying to get this school district to implement the policy. But so far, they have not adopted it. The Florida Department of Education, however, recently, just a couple of weeks ago, issued a model policy for school boards in order to implement the law to employ chaplains. So our organizations have been studying this model policy, and Rachel Lazar, the CEO here at Americans United, actually called it a model of unconstitutionality. It's really bringing in spiritual counseling into our public schools. So now I'm going to shift and talk about the 10 Commandments. As these bills about chaplains were permeating through the through the states, They often went hand in hand with a bill to post a display of the Ten Commandments in public school classrooms. And in one particular state, that law passed in Louisiana and now requires every public school classroom in the state of Louisiana, from kindergarten through public universities, those classrooms have to have a copy of the Ten Commandments posted. So this is settled law. As Ian mentioned, the law around religion in the public schools has historically been very, very strong and protective of our public school students who may be of varying faiths or none. And in the 1980s, the Supreme Court directly addressed a similar law in Kentucky over a posting of the Ten Commandments in classrooms. In the case Stone versus Graham, the Supreme Court overturned that state law, saying that the Constitution forbids public schools from posting the Ten Commandments in their classrooms. They found that the requirement had no secular legislative purpose and was plainly religious in nature, touching on those factors from the Lemon decision that Ian mentioned earlier. The court also noted in that case that the commandments did not confine themselves to arguably secular matters, such as murder or stealing, but rather concerned matters such as the worship of God and the observance of the Sabbath. After Governor Landry in Louisiana signed this bill into law, Americans United and our allies filed a lawsuit on behalf of 9 Louisiana families with children in their public schools. They come from a variety of religious and non-religious traditions, but all object to their religious freedom being violated by this display. The lawsuit contends that the Ten Commandments Act in Louisiana violates the Establishment Clause and also the Free Exercise Clause. This law was a transparent attempt to pressure public school students to convert to a state-preferred brand of Christianity. And we are contending that the Ten Commandments posting in public school classrooms violates the religious freedom of every student in Louisiana. The First Amendment guarantees that students and their families, not politicians, governments, or school officials, get to decide what religious beliefs, if any, they adopt and what role those beliefs will play in their children's lives. This law blatantly violates the Constitution, and to date, no federal court has upheld the display of the Ten Commandments by public school officials, regardless of context. And that's for good reason. Public schools shouldn't be used to religiously indoctrinate or convert students. And notably in that case, Christian and Jewish communities from Louisiana have also spoken out against this law because they believe that that responsibility lies with parents and families and not the school officials. So this case was just filed earlier this year, and at the end of this month, there's going to be a hearing in federal district court down in Louisiana on several different motions. One is a motion from the defendants to dismiss the case, but then they're also going to be hearing our motion for an injunction to prohibit the display of the Ten Commandments in classrooms. So that's going to be happening at the end of this month, so stay tuned, and you can check out updates at au.org on that case. Now I'm going to switch and talk briefly about how curriculum standards are changing and there are efforts around the country to inject religion into public school curriculum. The first place that that's happening is in Texas. In May of this year, the Texas State Board of Education proposed an update to the state's kindergarten through 5th grade reading language arts curriculum. This was immediately described as a Bible-infused proposal, and it seeks to inject biblical teaching into elementary education. So I'm going to give just an example of what this curriculum would look like if it's adopted. So there is an example of an art lesson which will be taught in the context of the creation story from Genesis. This is a lesson that was designed specifically for kindergarten students who, as you may know, are 5 and 6 years old. And here, the lesson discusses the story of creation from the book of Genesis, and then it asks kindergartners to repeat back the sequence of how things were created from the story. For example, that God created light, then seas and land, and then birds and fish, and then animals, and lastly, Adam and Eve and the Garden of Eden. So this is a very timely topic. The State Board of Education in Texas is meeting this week to discuss this proposal and vote on its adoption. And just yesterday heard 8 hours of testimony about it. So if it is adopted by the State Board of Education, this curriculum will go into effect for the next academic year, so 2025 and 2026. And now I'm going to shift to the state of Oklahoma, where a lot is happening, and Ian kind of teased that a little bit. The biggest thing that Americans United is working on in the state of Oklahoma involves the nation's first religious charter school. In June of last year, the Oklahoma Statewide Virtual School Board approved an application from a Catholic school, St. Isidore of Seville, to become the nation's first religious charter school. The Catholic school did not hide the fact that it planned to operate as a Catholic school, and that Catholic doctrine would be taught in all subjects throughout the school. The school also said that it would exercise its right as a religious organization to discriminate, and that includes on the basis of religion, sexual orientation, gender identity, pregnancy outside of marriage, and sexual activity outside of marriage. They also notably said that they would discriminate based on disability. So in July of 2023, Americans United, again with our allied partners, the ACLU, the Freedom from Religion Foundation, and the ELC, filed a lawsuit in Oklahoma State Court to challenge the approval of this charter school. At the same time, Oklahoma's own Attorney General also filed a similar suit, saying that this violated the state law. In June of this year, the Oklahoma Supreme Court ruled in the Attorney General's favor, incorporating in its opinion many of the arguments that AU made in an amicus brief or a friend of the court brief before the Supreme Court. Given that decision, the defendants in the case have agreed that the religious school will not open this year. And under the agreement, the lawsuit was actually put on hold until early next year. It's expected that the virtual school board is going to appeal to the United States Supreme Court, and we should find out by the end of this month, early next, if that is going to happen. The other big thing that's happening in the state of Oklahoma, again, as Ian alluded to, is that the state superintendent of education, Ryan Walters, issued a mandate to include the Bible as part of the curriculum in the state of Oklahoma. In a memo that he issued, he stated that the memorandum and standards must be given to the public school officials, and school districts must provide to every teacher a physical copy of the Bible, the United States Constitution, the Declaration of Independence, and the Ten Commandments as resources to use in every classroom in the school district. These documents are mandatory for what he called a holistic education for students in Oklahoma. The guidelines that Walters issued to use the Bible in the classroom are actually beyond his authority. Under Oklahoma state law, Oklahoma's public school districts are empowered to establish their own curriculum and select what texts are used in the classrooms. AU has been very active on this issue, has submitted open records requests to investigate further about what this means for students in Oklahoma. And we are assessing our options to include potential litigation in the state of Oklahoma. We are definitely ready to step in all of these states to protect public school children and their families. And we urge anyone who are in those states who might have a school district that is implementing a policy for a public school chaplain or a posting of the Ten Commandments or the Bible uses curriculum in the state of Oklahoma to reach out to Americans United and let us know if you have a violation that you would like to report to us and we can take a look at. And now I think we are ready for questions.
Thanks, Rebecca and Ian. That was all very informative. So now we're going to get to our Q&A period for this evening. So if you do have questions, I'll just remind you, please put those in the chat or in the Q&A box. We do have a few trickling in already, so I'll just go ahead and get started on those. Billy asks, are there Supreme Court cases in the queue that could impact this issue?
I can take that one. Not for this current Supreme Court term. There was a lot of damage done in 2022 when the Kennedy decision came down. That decision came down at the same time as another decision affecting religious liberty in the United States, Carson v. Macon, which talked about funding to religious institutions. And so a lot of the cases and litigation that we're seeing now are still percolating in the lower courts. So it's very normal that right now we don't see anything at the U.S. Supreme Court, but could in a couple of years. A lot of these cases have also shifted to state courts. And so those are wending their way through the state court systems and going to state Supreme Courts, who, like I mentioned, could potentially have their decisions reviewed by the Supreme Court, depending on the circumstance. But the short answer to your question, and Ian said we use a lot of jargon, lawyers also talk a lot. So that very long-winded answer, the short answer to your question is no, not at this time.
Thanks, Rebecca. Ray asks, Louisiana's Dream Big set of education laws is huge. Are there similarly sized efforts in other states?
So, Rebecca, I don't know, are you familiar with this the Dream Big initiative that he mentions? Because I'm not.
I am also not. Unfortunately, we're both in the legal department and not in our policy department. But yeah, I don't actually know the answer to that.
I can speak generally to this. I think like there are like if you've never looked at like the regulations and laws that apply to educational institutions, I mean they're massive, they're huge, and they're changing all the time, and legislatures add and subtract things from them all the time. That's one of the reasons why our policy department here is so important, because they monitor these sorts of things and try and find the stuff that's really bad and to prevent it before it gets into actual education law. And so like, I don't know if there are specific like initiatives similar to the one you're talking about, but like these kinds of policy changes to the law happen all over the place all the time. So it wouldn't surprise me.
Thanks, Ian. I believe it's Jamie asks, referring to the charter school in Oklahoma that wants to integrate Catholic doctrine into each subject, is the charter school considered a public school? And if so, does this charter school expect to be tax exempt?
So yes, under Oklahoma state law, charter schools are public schools. And I actually don't know the answer. Do you, Ian, about the tax exempt status of?
Yeah, I don't know if they filed for a tax exemption or not. I mean, like a lot of charters, I think, operate as nonprofits, like generally, because they don't operate for a profit. But I don't know about the school specifically.
But they are most definitely considered a public school. All charter schools are in the state of Oklahoma.
Ray also asks, does the Federal Department of Education have no authority to influence any of the religion or the religious cases?
So I can actually take this. As it turns out, our previous legal director, Richard Katsky, worked at the Department of Education. So I've talked to him about this specifically. So the Department of Education has a civil rights division, right? But the civil rights division at the Department of Education has a very specific and narrow remit of things that it looks at. And as far as I can tell, that remit does not necessarily include violations of the separation of church and state. It does include things like discrimination on the basis of religion, but not necessarily Establishment Clause violations. So the Department of Education tends to stay out of this question because it is not technically within the remit of their civil rights division.
I'll just tack onto that. They do issue guidelines for school districts and school officials just on religion in schools, but those guidelines are very, very general and have a tendency to change depending on who's in the White House. So they're not particularly helpful either.
Someone asks, so a lesson in a freshman high school English class that requires students to annotate the story of Noah's Ark. Is this crossing the line, on the line, or is this okay?
I can take this one. It depends on the context, right? So it depends on what the lesson is intended to convey, right? So that's the kind of thing where if it were to come in to our reported violation form, I'd ask to see the actual like lesson handouts. You know, I want to know what the teacher was talking about, right? In context with the class, because just using the story of Noah's Ark might not be a violation, depending, right? If it's used in a secular way for a secular reason, then maybe it's fine. Noah's Ark would be a story that I would tend to classify as something more on the line, right? It would be something that I would consider to be more suspicious than certain other stories. But again, I'd need to see the context.
Thanks, Ian. Back to the chat. Have there been cases where states or school districts tried to create religiously based public schools and they have been disallowed due to opposition by legal action or public outcry?
Could you read that one more time?
Yeah, I think this is getting at basically, is the situation in Oklahoma with the charter school a new thing, or has this been tried before? You know, have there been, so the question asks, have there been cases where states or school districts tried to create religiously based public schools and they have been disallowed due to opposition by legal action or public outcry?
Okay, no, the situation in the state of Oklahoma is the first of its kind. So this is the first time a religious charter school has been approved by a state and is now being challenged legally.
Yeah, the closest thing to what you're thinking about was it ultimately isn't exactly the same, but the closest thing was that there was a case where a Jewish day school got a township created like a little district, like specific school district for that religious school. And that was disallowed because it was found to be special treatment of a religious thing. But the school itself was private. And then the government action was to try and create this like little special district for it where it could get all kinds of benefits and stuff like that. But that is the closest that anything has ever come to what you're talking about. And certainly nothing like what's happening in Oklahoma.
All right, Billy asks, school boards in the state of Colorado have enormous autonomy and seem to be able to make decisions similar to the ones you are seeing at the state level in the list of states you mentioned. How do these smaller entities, local districts, combat the lack of separation of church and state?
So for something like that, if you see I mean, I hear what you're saying about Colorado, especially. Colorado is actually a fairly common site of complaints because there are several large religious right groups that operate in Colorado and have a lot of influence on like local school boards and stuff like that. And what I can say is that the local school boards are under the same constitutional requirements as anybody else, right? And so if you see something happening at a local school board that seems like it's a problem, then contact us about it, right? We can't always do something about it. Like sometimes, we get contacted a lot, especially in Colorado, which is why it comes to mind about school board, officials like mouthing off, in the press and stuff like that, right? Which we can't always do stuff about. But if they take any actions like similar to the ones we've been talking about here, then yeah, contact us and let us take a look at it because they have to follow the same rules as anybody else.
Heidi asks, or Terry, I suppose it is, asks, I am also in Texas. I live in Cypress Fairbanks School District, which is the third largest district in Texas and is currently being run by a school board with a 6-1 Christian nationalist majority. In contentious school board meetings, we often hear the same arguments from lawyers supporting their viewpoint. They also talk frequently about the, quote, overinterpretation of church-state separation. I'd like to hear more from the attorneys about these arguments and how us regular folks can respond to them in real time.
It's a very good question. I think you can take a look at the Know Your Rights guides that Ian mentioned earlier to get a basis of what is permissible and what is not. Draw on the fact that the courts, despite some of the changes that we've seen over the last couple of years, the courts have always jealously guarded the rights of public school students because of the nature of who they are, young, impressionable students who are a captive audience to these public school officials. So as much as there are efforts to change and to dismantle the wall of separation in the public school context, it is still very strong. and the case law, decades upon decades of case law, is really on our side there. So I would encourage you to take a look at the guides that we have, and speak out when you're hearing those arguments. I
And
don't know
as
if
far
you.
as over-interpretation of church-state separation goes, I mean, like the Supreme Court loves to talk about history. So talk about history. Like the reason that a lot of people came from England to the United States in the first place was to get away from government-established religion. So what does over-interpretation mean? I mean, like this is foundational to the DNA of the United States. And I mean, the all the things that they want to do were things that England did on behalf of the Church of England that caused all kinds of bloody inter-religious conflict over there, and that the founders of this country specifically chose to try and get away from, right? So I don't know how you can over-interpret that. That's sort of the tack I would take if you're comfortable in digging into the history of it. I mean, I know that in a lot of those cases you probably only have a little bit of time to actually talk, but that's just the truth.
Lindy asks, is the Kennedy decision the main reason we are seeing these recent efforts from the religious right?
I don't think that it's the only reason we're seeing these efforts. I mean, this has been a coordinated effort for more than 40 years. We saw a lot of efforts by the Christian right in the 80s to dismantle church-state separation in public spaces, like attacking nativity scene displays and legislative prayer at those cases came down from the Supreme Court in the 80s, upholding those practices. And then they moved to other areas. The schools are sort of the last bastion of church-state separation. And so we are seeing more efforts to inject religion into schools because of Kennedy, but I don't think it's solely because of Kennedy.
Now, one of the things that I want to elaborate on something Rebecca just said, that it's been a long effort for the religious right. So one of the things that they have been doing for decades and decades and decades is getting together like-minded young lawyers, right, and networking them. And those lawyers end up being people like the people that end up on the Supreme Court, or the people that end up arguing cases in the Supreme Court, right? And this has been an ongoing effort for them. And AU and its partners, including ACLU and others, have recently, we've started our own system where we bring together, it's called the Legal Academy. So we bring together law students during the summers to meet each other, people who are interested in civil rights work and in these kinds of issues, to network together so that they get to know each other and to get trainings on, how to do effective legal advocacy in these spaces, right? And it was specifically conceived of as an effort to try and start building something on our side that's the equivalent of the network that the Christian nationalist movement has been working at for decades, right? So it's still in its infancy, but we've been having a lot of success with it. And hopefully that will pay forward some of this stuff in the future.
Ray asks, lawsuits are churning related to Carson v. Macon here in Maine. Does AU have the resources to get involved in every state case?
Well, we are looking to submit an amicus brief with our coalition partners in some of the cases that are churning in the state of Maine. That is all of the cases that have come as a result of Carson v. Macon, we're very closely following and making sure that AU's voice is represented in those cases, mainly through amicus briefs. But we're also looking at how and when we'd be able to get more directly involved as a party. We do have limited resources and have a national scope, but it is one of our priorities to cabin the effect of Carson versus Macon.
We have a question here. Well, I think this will probably have to be our last question. But we have a question here in the Q&A box, and I know we weren't quite able to get to everyone, so hopefully you were able to learn enough from this evening to go out into your lives and feel equipped, and go through those Know Your Rights guides as well, because hopefully your questions will be answered there. So the last question is relating to vouchers for private schools, and if taxes are paid to support local school districts, how can those tax dollars be taken and spent on money for vouchers for public or for private schools?
You want to take that one, or you want me to?
Yeah, that's you can go ahead and I'll tack on.
Sorry, so vouchers are frustrating, and unfortunately, there's not a lot we can do about them from the legal side. So, the answer to that question is that the Supreme Court doesn't see the money. It sees what it calls a circuit breaker, or what I actually don't know if they use that term. That might be one of my old bosses use that term, a circuit breaker between the government's action, which is to give out the money, and the decision to give that money to a religious school. So here's the rationale, right, from the Supreme Court. The government doesn't give the money to the private religious school. It gives the money to the parent, and then the parent decides that the money goes to the private religious school. And the Supreme Court says that breaks the circuit between the government's action and the funding of the religious institution, that decision is private and done by the parent. I don't know that I buy that reasoning, right? But it's pretty well established at this point. And a lot of the work on vouchers, because of that decision from the Supreme Court, has to go through our policy department, right? Like, they work really hard to try and stop voucher bills, before they get enacted into law. And also, don't forget, even if your state has a voucher bill, right, usually those are time limited, right? Like, they are funded for a few years, and then they come up again for renewal. And our policy department also works to try and get, when these renewals come up, to try and get states to not renew them. And that actually, within the last year or two, they actually succeeded in that in at least one place, right? So it's not permanent, and the way to get at it is political, not legal. But that is sort of the basic explanation of why vouchers are allowed.
Well, thank you, Rebecca and Ian. That wraps up our time for this evening. Thank you so much, and thank you also to our co-sponsors, the ACLU of Oklahoma and Secular Student Alliance. A reminder that this webinar was recorded, and all registrants will receive an email tomorrow with a link to this recording, as well as links to all the resources that we discussed tonight. You'll also receive an email letter later this evening asking you to provide your feedback on this program, and we really do appreciate getting your responses. So if you have a minute to do that, please do. Thank you all so much for being with us tonight, and have a good evening.